Good afternoon, everyone, and greetings. As my colleague, Christine Wilczynski-Vogel, has said, welcome to Eckstein Hall and to our Lubar Center. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to welcome you today and to introduce our Hallows Lecture. Let me begin by recalling the person in whose memory this lecture stands. E. Harold Hallows was a native of Fond du Lac, Wisconsin, who practiced law in Milwaukee from 1930 to 1958. Throughout this time, even to omit his other connections with Marquette University, Hallows taught part-time at Marquette Law School. Every Tuesday and Thursday at 8 a.m., a generation of future Marquette lawyers took equity and Equity 2, required courses at the time, from Professor Hallows. Hallows was a most engaged public citizen, especially in matters involving law reform and the courts. In 1958, when Roland Steinle, a Marquette lawyer, stepped down from the Wisconsin Supreme Court, Governor Vernon Thompson appointed Hallows to the court. He was then elected in 1959, and in 1969, now as Chief Justice, re-elected, serving until his death in 1974. This was a most dynamic time in legal doctrine. No less important was Hallows' work as Chief Justice in promoting the court reorganization that in the 1970s would give us the modern Wisconsin court system. In short, whether as a practicing lawyer, law professor, or justice of the court, for more than 4 decades, E. Harold Hallows was at the center of things in Wisconsin's legal profession and community. It was to celebrate and recall all aspects of his career that Marquette Law School in the 1990s created this annual lecture. Our lecturer this year, the Honorable Gerard Lynch, comes to us from New York. He is a native of that city, attended one of the city's Jesuit high schools, its best one, he would tell you, Regis, and he has some basis for that view, and then received an undergraduate classics degree and a law degree from Columbia University. He clerked for Judge Wilfred Feinberg of the U.S. Court of Appeals for the Second Circuit and Justice William Brennan at the Supreme Court of the United States. He then returned to Columbia as a faculty member, only to conclude that he would like some experience in the practice. So he became both a trial and appellate lawyer at the U.S. Attorney's Office for the Southern District of New York, and eventually chief of its criminal division. During this time, he was back and forth to and from Columbia, returning full-time and serving for a number of years as the Paul J. Kellner Professor and as Vice Dean. Then he became Judge Lynch, being appointed to the federal trial bench, Southern District of New York, by President Clinton in 2000, and then in 2009 to the Second Circuit by President Obama. None of this could persuade him to leave Columbia, where he has continued to teach courses as varied as criminal law, civil procedure, and even literature humanities, a freshman course in the college. These past 2 days, he has had, by our lights, a very fine visit, meeting with students, such as our judicial interns, and at his request, leaders of our first-generation professional student group. We are now arrived at the Hallows Lecture, for which Judge Lynch will take up, indeed, as I understand it, praise complexity and contradiction in American law. Won't you please join me in welcoming to Milwaukee and Marquette Law School the Honorable Gerard Lynch.
Thank you, Mr. Dean. This is indeed the annual Hallows Lecture for spring 2020. It's just been delayed. Of course, it's not as if I wrote it in 2020 and have been polishing ever since. We all know that's not how lawyers work. I kept thinking maybe I'd never have to do it. The pandemic might go on forever, and then I would be spared. Okay, We start with Ronald Dworkin, Taking Rights Seriously, published in 1977, but based on articles he'd written in the preceding years while I was a law student. One of the most influential books on jurisprudence of the latter 20th century. It certainly had a profound impact on my thinking as a young lawyer about how courts should decide hard cases. In recent years, I've been revisiting my initial infatuation with Dworkin's theories in light of my experience over a long career as a legal academic, lawyer, and judge. A few years ago in the Madison Lecture at New York University, I questioned Dworkin's argument that there are objectively correct answers to even hard legal questions, concluding that HLA Hart had the better of their disagreement and that some legal questions do not have clearly right answers and are left to judges to resolve based on their own best judgment. Today I want to begin by talking about a sub-issue, really, in his theory, Dworkin's analysis of how judges should approach hard cases and reach right answers, as a springboard to introduce some thoughts about whether a certain degree of incoherence and inconsistency in law might actually be a good thing and in any event is more or less inevitable. If you believe there are definitive right answers to difficult legal questions, you have to provide a methodology for how to reach those right answers. In his early writings, Dworkin's signature move was the suggestion that the ideal judge, whom he called Hercules, should formulate a view as to the overall structure of the law. And this is a quote, "to construct a scheme of abstract and concrete principles that provides a coherent justification for all common law precedents, and, so far as these are to be justified on principle, constitutional and statutory provisions as well. The best answer to a hard question is the one that best fits that comprehensive scheme." As many pointed out, and as Dworkin freely acknowledged, that approach would not lead to predictable or objectively determinate answers. The number of data points necessary to construct such a grand theory of American law was sufficiently large and diverse that different judges, depending on their own policy or political preferences or values, would necessarily construct different grand structures. Dworkin also recognized, as was more or less conceded by christening his ideal judge Hercules, the task of bringing together all of the breadth of American law into a single system was probably beyond the reach of a mere mortal. Most judges wouldn't be up to the task. My argument is really a more radical version of those concessions. It's not just that there are competing, shall we say, liberal and conservative versions, and no doubt many other versions, of the grand structure of American law, so we won't all agree on what the structure really is. It's not just that it would be hard work to devise one's own theory of the grand scheme. My conclusion is that there just is no there at all. There isn't and can't be a single overall vision that fits together all of American law, even if we're allowed, as Hercules was, to discard at least some data points as outliers or mistakes. American law does not proceed from a single mind, a single Solon, who created some grand system that we have to devise. It instead comes from generations of different judges, different lawyers, different legislators, operating at different times and different places, coming up with answers to particular questions. I think it's reasonably clear that the body of American law, both in general and even in certain specific areas of substantive and procedural law, is the product of both temporal and spatial divergence. It's the product of an accretion of rules and principles embedded in law as it has evolved over time through different dominant theories of law in different eras, each leaving their residue behind, and divergent traditions that have evolved separately in different states or regions. Let me talk about the temporal first. It's clear from our history that law and legal philosophy change fairly dramatically over time. We think in relatively parochial terms about the shifts from the Warren Court to the Rehnquist Court to the Roberts Court or something of the sort. But in fact, this change has taken place over a much longer period of time and has changed more consistently than it's ever stayed the same. Judges, lawmakers, legal philosophers faced different sorts of problems, had different background notions about how to solve problems, different understandings of the world at different times. Our methods of legal education tend to obscure this truth. Casebooks serve up snippets of old Supreme Court opinions, selected to some degree based on contemporary understandings of what was important and lasting about the holdings of selected cases, and including in the book only the reasoning that supports that part of their holding that remains relevant today. Few law students are assigned to read the entire text of all the opinions of the justices in, say, the Dred Scott case. If you do, you will encounter a very different legal landscape. It's not only that, of course, today's reader is shocked by the overtly racist assumptions underlying the majority's holding. Those views may have been more prevalent then, but they continue to exist even now, and they were not universally shared even then. Justice Curtis's dissent calls out the majority on those assumptions in a way that resonates with present-day values, as much as the majority opinion offends them. But more fundamentally, none of the opinions reads like a contemporary Supreme Court opinion. Yes, in one way or another, the opinions address constitutional text or opinions attributed to the framers. But consider the absence of footnotes. That is superficially striking. The page looks different than a page of today's US reports. But it's also symbolic of a very profound difference in method. The court was much more comfortable with ipse dixit subjective reasoning from common assumed truths about our history without any pretense to scientific history or citation of authority. The difference in style is indicative of a difference in the basic assumptions about how courts should reach their results. It would be interesting to track such changes of judicial reasoning systematically from the time of John Marshall through the pre- and post-Civil War eras to the heyday of the Lochner doctrine in the Gilded Age, through the New Deal court and its post-World War II fragmentation, and then reassembly in the time of Earl Warren, to the Scalian originalist textualist formulation of the present. But the point is, the familiar one, that the past is another country. Indeed, it's a series of different other countries evolving into each other. We can't readily assume that the data points plucked from that sequence will arrange themselves into any coherent framework. Another feature of the legal landscape contributes to this problem. The past, for a legal system that values consistency and looks to precedent, is never entirely past. We may have overruled Dred Scott by constitutional amendment and forgotten a host of other precedents no longer deemed relevant. But each of the different waves of legal thinking has left its residue in the operative corpus of law. To some extent, the cases from the 19th or 20th century that continue to be cited with any frequency today may be ones that have stood the test of time and continue to resonate with contemporary values. But that's not always so, especially when we recede from the major landmarks of constitutional law and consider more mundane areas of the law. The law of property, the law of conflicts of laws, the principles of substantive criminal law, to take just a few examples, are studded with specific rules that continue to be applied just because they're there, because judges and lawyers are used to them, because they work well enough, even though they may not be the rules that would be dictated by contemporary frameworks of legal thinking. When new ideas or methods of legal analysis come along, we do not usually engage in a wholesale revision of the entire body of law that has accumulated over the centuries. We just go on with what we find acceptable and change some things to accord with the new thinking. To take one example almost at random, familiar to all lawyers from their first-year course in civil procedure, the law of in personam jurisdiction. That body of law got a major shakeup from the New Deal court in International Shoe in 1945. But even almost 50 years after that revolution in thinking, the Supreme Court adhered to the traditional rule that permits a state to gain jurisdiction over a non-resident defendant by serving process on him while he was passing through the state, even where that claim had nothing to do with that state and where that defendant had no particular contacts with the state. That rule could not really be squared with the new philosophy. It derives from an earlier way of conceptualizing in personam jurisdiction. Nevertheless, the court stuck with the historical rule to which it was, with which everyone was familiar, rather than trying to shoehorn it into the newer way of thinking. And for the last generation or so, the court has taken up a newer, but also in some ways older way of thinking about the territorial limits of state jurisdiction to curtail the application of what's called general jurisdiction, rejecting the analysis that my generation of law students was taught was a logical corollary of international shoe. The result is a set of rules that coexist. They don't necessarily contradict each other, but they're hard to reconcile according to any single theory. They are best explained as rules that represent the residuum of at least 3 different legal philosophies that prevailed at different times in our history. When such a broad shift in philosophies occurs, some specific rules may be ripe for challenge. Indeed, the perception that we may be doing something very wrong may be part of the impetus to rethinking how we analyze problems. But again, we don't typically bulldoze the entire structure of existing practice and rebuild according to the new approach. Rather, we fix on an ad hoc basis the problems that seem most egregious. The rest of the ramshackle structure that the law inherited from earlier generations and their very different types of jurisprudence continues to stand. That is all the more true of statutory law. Title 18 of the United States Code is somewhat ironically called the Federal Criminal Code. I say ironically because it's not a code at all in the sense popularized in the 1960s by the American Law Institute's Model Penal Code. That is, an integrated structure with a general part containing definitions and basic principles that are then implemented in specific criminal prohibitions and penalties defined to address particular types of wrongdoing. Rather, it's a hodgepodge of criminal statutes, some of them dating all the way back to the earliest Congresses, others of more modern conception. You can see the differences again right on the page. Pull a criminal statute from the early 21st century, and you see a pattern of complex subdivisions with letters and numbers, and carefully worded statutes that aim, not always successfully, to appeal to the textualist brain of modern judges. But then look at the older laws that define traditional crimes like murder and assault when committed in the federal jurisdiction. Now you see something quite different. Laws that cannot be parsed as clearly defining conduct in precise language. Instead, they invoke broad concepts derived from the common law of crimes. It would not do to read them as if the specific words were designed to tell the naive reader exactly what elements define the crime. Rather, the words gesture towards common law concepts that require familiarity with Blackstone or with judicially created definitions of common law crimes. But both types of statute coexist in the same code, along with others drafted in eras with still other expectations about how courts would read statutes. There's a sort of Whiggish way of reading this history that suggests that the law develops teleologically. Sometimes it invokes Dr. King's famous suggestion that the arc of the moral universe is long, but it bends toward justice. But even if we put aside that King was speaking from a specifically Christian teleology, that ultimately history will resolve in God's just judgment, he did not mean, and it doesn't seem to be true, that the arc of human history bends inevitably in some particular direction. Contemporary Americans who may all believe or hope that history is bending toward justice turn out to disagree radically about what a just world would actually look like. More characteristic of American law than an arc pointing in a particular direction are cycles and eddies, movement that seems headed in a particular direction and then reverses. For example, the advance in human liberty that culminated in the end of slavery rapidly devolved into a period of reaction and inequality featuring lynchings and Jim Crow laws. That regime was upheld by the Supreme Court and lasted the better part of a century. That was followed by a long period of liberal political ascendancy and judicial creativity. that for a couple of generations appeared dominant and irreversible, followed by a period of stasis and retrenchment that now seems headed towards a period of conservative activism. The reversal of that trend seems as unlikely now as the reversal of the progressive jurisprudence of the 1950s and 60s might have seemed as late as the mid-1970s. And of course, that's just to look at the high-level constitutional jurisprudence of the Supreme Court, which preoccupies American legal philosophy. Even at that level, trends in things like separation of powers and federalism and states' rights probably follow a different path that does not correlate perfectly with liberal versus conservative politics. Both liberals and conservatives seem to value judicial restraint or states' rights according to which branches of the federal government they control, more than from any consistent principled preference for executive power versus legislative, the proper role of the judiciary, or the extent of federal authority over local matters. And the picture with respect to trends in the dominance of statutory and regulatory law, modes of statutory interpretation, attitudes towards litigation reflected in rules of civil procedure, and what remains of the common law fields of property, tort, and contract may roughly follow leftward or rightward trends in politics, but are subject to their own vagaries and more specific evolving notions that only roughly correlate with those large trends in constitutional law. And of course, geography matters as well as history. Of course, Dworkin didn't really expect judges to construct a coherent structure of American law as opposed to the law of a particular jurisdiction, federal or state, New York or Wisconsin, within which a particular judge sat. After all, the United States is composed of 51 at least sovereign entities, each entitled to diverge and develop their own bodies of law within very broad limits set by the Bill of Rights. Projects that aim to state common law rules that represent American law, most notably the restatements issued by the American Law Institute, face a challenging task. Many black-letter principles derived from the common law are common to all or a great majority of states. That's like the easy cases that are very easily settled by courts. After all, we share many aspects of a common Anglo-American legal culture. But on the hard calls, divergence is common. And the ALI has a hard time identifying what to put into even heavily caveated black-letter law. The diversity of rules across states has influence even on the development of federal law. Conceptually, the United States is a separate sovereign that geographically overlaps the territory of states, the states that make it up, but that operates independently within its assigned spheres, as distinct from New York or Wisconsin as New York and Wisconsin are distinct from each other. But that Madisonian conception appears fuzzier in practical operations. The federal appellate courts are organized into regional circuits whose judges are almost always selected from the bars of the states within each circuit and can be expected to share the cultural and political predilections of their regions and legal assumptions drawn from the laws of the states in which they have practiced or served in the judiciary. In a world in which the Supreme Court now hears as few as 65 cases a year out of the many thousands decided in the courts of appeals, it is not surprising that uniformity on questions even of federal law can be elusive. And if that is true of formal legal rules, it is probably even more true on matters of practice or matters confided to the discretion of trial judges. Consider the period from 1987 to 2005, during which federal sentencing was supposedly constrained by mandatory nationwide guidelines. Sentences in different circuits and even different districts within circuits varied considerably as judges exercised their limited discretion more aggressively and in different directions in different places. Rates of departure differed systematically, often influenced by the disparity between nationwide rules and the sentences customary under local law for similar conduct. The Madisonian underpinning of the sentencing guidelines system was the belief that it was unjust for a federal convict in New York to get a very different sentence from one convicted of the same federal crime in Texas. But there's a different equity concern when someone commits a crime that could be prosecuted in state or federal court in either state and faces a very different sentence depending on whether the officer who made the arrest brought the case to a state or federal prosecutor. Given all of this temporal and geographic disparity in American law, I think it's fanciful to imagine that anyone could come up with a truly persuasive argument that a genuinely hard case could be resolved by reference to the purported congruence between the judge's preferred answer and the grand sweep of American law. But of course, as I told you at the beginning, I believe that no formal principle can dictate convincing neutral answers in the small but important category of truly hard cases, where the plain meaning of a controlling text or a convincing similarity of the case to a controlling precedent does not dictate the results. Don't misunderstand. I tried to be clear in my Madison lecture that I was speaking of a category of cases, perhaps large in absolute numbers or in salience, but very small in proportion to the total range of legal questions that could be asked. To most cases, there are correct answers. Lawyers know them. They tell them to their clients in their offices. The clients abide by them. And that's the end of it. We don't get litigation over those cases. It's only a few categories of cases that are genuinely hard. And of course, I don't mean to suggest that the law should be entirely chaotic. If hard cases cannot be resolved according to some overarching philosophy, it's nevertheless a good thing that they be resolved. Because then, in a world ruled by precedent, once the highest court of a particular jurisdiction has decided the issue, the formally hard case becomes an easy one. Fairness and predictability are furthered by definitive legal resolution. But what counts here is a definitive resolution of a particular recurring legal problem. It is not a need for consistency in underlying philosophy. Clarity of rules on a particular issues is important. Consistency of the deep principles of decision-making or the abstract theory that led to the results, to the resolution of each rule, maybe at different times in different places, perhaps not. Indeed, the search for underlying consistency may be unsettling to stability, as the history of conflict of law rules in the late 20th century showed. Then a new theory, widely adopted by judges and embraced by the second restatement of conflicts of laws because it was more helpful in resolving a few particularly difficult legal problems, called any number of formally widely settled rules into question, resulting in great uncertainty. The current third restatement is to a considerable degree reasserting a number of simpler, more traditional rules because the effort to achieve theoretical consistency led to more turmoil than was good for the law. So before I turn to talking about some of the advantages of inconsistency, I want to explain a little bit about how some of that comes to be, and I want to do it by speaking a bit about the very mundane question of the organization of the federal court system, and suggest how the differences in the selection, experiences, and functions of different levels of court help generate diversity of results and inconsistent principles and methodology. As you all know, there are three levels of the federal courts: the trial level district courts, the intermediate courts of appeals, and the Supreme Court of the United States. On paper, they have some similarities. They're all charged with applying federal and sometimes state law fairly and impartially to resolve all manner of disputes. The judges on all three levels enjoy life tenure after being appointed by the president with the advice and consent of the Senate. But there are profound differences in the processes by which the judges are selected and the functions that they perform in administering our legal system and the way that they operate. When most ordinary people are asked what they think of the federal courts, which pollsters frequently do, when political pundits discuss the role of courts in our government, even when law professors devise theories of jurisprudence, they all seem to focus disproportionately on the distinctive role of the Supreme Court. In recent years, that court hears no more than about 70 cases on the merits. Probably no more than half of those involve the major constitutional issues of great political and social interest that dominate the front pages. Examples of the most extreme level of controversy and public concern would be recent cases like Dobbs, which overturned the constitutional right to abortion announced nearly 50 years earlier in Roe against Wade, and Bruin, which invalidated New York's century-old law requiring a special license to carry a firearm outside a home or business. For many years now, the process by which the members of that court are nominated and confirmed has drawn great public scrutiny, including nationally televised confirmation hearings, highly contentious political debates focused on how the nominees are likely to vote on issues expected to come before the court. It may be hard for younger lawyers to even grasp the fact that in the 1950s, President Eisenhower's appointment of justices like Earl Warren and William J. Brennan received little public attention and resulted in confirmation by overwhelming majorities after fairly perfunctory hearings. Increasingly, presidents nominate to the court younger candidates than was once the norm. Why? To maximize the length of their service on the court. And candidates who, because of their track record as judges or law professors, have taken positions on legal issues that can help predict their views on upcoming constitutional cases. Although a few justices have retired from the court for personal reasons while still healthy and able, the public and political commentators seem to expect justices either to serve out their full life sentence, their full lifetime tenure, or as suggested by the widespread criticism of the otherwise lionized Justice Ginsburg for doing exactly that, to time their retirements to the political convenience of a president of the same party as the one who appointed them. Now, the inferior federal courts, as the Constitution calls us, have very different dockets. Something over 400,000 cases are filed annually in the federal district courts, approximately 50,000 or so appeals in the various circuit courts of appeals. Most of the cases that reach the Supreme Court come up through those courts, though some also come from the even busier and more diverse state court systems. The functions of the judges in courts are quite different at each level. District judges have the least power to make law by the cases they decide. Their opinions are not binding on any other of the 670 or so district judges hearing similar cases, though the number of cases and issues they decide so far outstrips the number of cases heard and decided at higher levels of the system that district judges look for, rely on, and cite as precedents the opinions of other district judges in addressing the legal issues that come before them. But district judges may have the most power of anyone in the system to affect the outcome of the particular disputes they are charged with resolving. Deciding formal legal questions is only one part of their jobs, while for the Supreme Court, that is quite literally the only thing the judges do. District judges supervise pretrial litigation, preside over trials, and encourage settlement. Many rules of law, procedure, and evidence vest district judges with discretionary authority to decide what to do in particular cases as they see fit. The wise district judge is not usually looking over her shoulder at what the Court of Appeals might do, though the careful district judge will often take care to create a clear record of the decisions she makes and the reasons for them. District judges know, however, that most of the decisions they make about legal issues as well as practical administrative matters will never be reviewed, because most cases eventually settle. The settlement terms are strongly influenced, perhaps, by rulings the judge has made, but because they never reach a final judgment, the decisions made by the judge in the course of the case may never be reviewed at all. Moreover, even the cases that are litigated to ultimate resolution and even are appealed will be presented to the courts of appeals based on a limited number of rulings selected by appellate litigators. And the governing standard of review will often grant considerable deference to the district judge. So while some of the district judges' decisions will attract public attention, even controversy, even most of those matters, like sentencings and high-profile criminal cases, are of passing public attention and do not implicate major political questions. In the few that do, the press mostly understands that the district court decision is only a way station en route to the resolution of that issue by higher courts. District judges, as a result, are necessarily primarily focused on doing justice to the individual parties who appear before them in the factual contexts in which abstract legal issues are presented by particular cases. This inevitably influences how the judges see the merits of broader legal questions. It can encourage judges to stretch the boundaries of abstract principles to do justice in particular cases. And since district judges decide nearly everything as solo actors, their individual understandings of what constitutes justice and fairness are their own and vary widely depending on their backgrounds, experience, and philosophies. Of course, judges are constrained by their oaths and also by inclination to follow the law as best they can discern it. But discerning it is not so easy. I was always amused when, as a district judge, non-lawyers would ask if I was often tempted to depart from the law to impose my own views. I would point out that I had to decide issues of law arising in an unbelievably broad range of legal specialties, from admiralty to bankruptcy, through insurance disputes and personal injury to securities fraud, pension benefits, intellectual property. In almost none of these areas did I have any pre-existing expertise or experience, still less any policy preferences. And even if I did, the issues arising in individual cases tend to be so highly specific that I would never have given them the slightest thought before they came before me. I was delighted when I could find any guidance at all in clear statutes or prior decisions of other courts about what the law was, so I wouldn't have to decide the more difficult question of what I thought the law should be. At the same time, for many questions, either the law was unclear or it clearly instructed me to exercise discretion and do what I thought was fair. And of course, what I thought was fair was the product of my own thought and experience. I don't think any sensible person would dispute that where the law gives little guidance, a particular litigant with a particular type of case who is given the power to choose his own judge, and I gather it's becoming increasingly common for some litigants to do that, would quite rightly think that he would be better off with a Republican than a Democrat or with a liberal than a conservative when close questions would need to be decided. Finally, there's the need for speed. I often would remind the clerks, and my law clerks in my district court days, that in all legal decision-making, there is a tension between getting it right and getting it done. Justice delayed is indeed justice denied, as the saying goes, and many issues raised by lawyers in the course of litigation are raised in hopes of securing a marginal advantage. Obtain a few more documents in discovery, get another piece of evidence excluded or admitted. Cumulatively, these issues matter, but each one has to be decided quickly. It will not affect anyone except these particular parties, and it will probably not be the issue on which the case is actually won or lost. It is any wonder, then, that under these circumstances, different judges will often reach different results. The courts of appeals are one step up in levels of abstraction. There, decisions set precedents that will affect a range of cases. While the context of a particular case can shape the way the court perceives an abstract principle, the wise appellate judge has to test whether what seems like a fair rule in this case will work in the broader range of cases to which it might apply. Unlike the district judge, we on the courts of appeals may never see the human beings who are parties to the cases, or we may see them only as spectators in the gallery. Moreover, appellate judges tend to be more like pathologists than like emergency room doctors. They dissect what went right or wrong in a case that has passed the point in which it has any urgency. If the parties needed an answer immediately, they would have settled the case long ago and gone on with their lives. The pressure to get it done remains. Even in a case that has been fully resolved below, the parties need to know in some reasonable time whether that resolution is final. Also, as at the district court, efficient resolution is important not only to the parties, but to the many others whose cases await decision. You can't take forever on any one case, however important and difficult it may be, because dozens of other cases are waiting in line for your attention. But on the Court of Appeals, the balance tilts a little further towards getting it right as opposed to getting it done. Now, the selection process for the judges who do this work is de jure the same as for Supreme Court justices, presidential nomination and Senate confirmation. But de facto, the political process has, for the most part, been quite different, and for good reason. Politics, in the most partisan sense, should, and for the most part does, play a lesser role in the selection and confirmation processes. Opponents of the president's party will snipe at candidates who seem, or can be made to seem, to stray from the political principles of the opposition party. But unlike nominations to the Supreme Court, which come up infrequently, the lower court benches must be peopled. so that the important work of resolving lawsuits can be accomplished. And while senators will often seek to score points off presidents of the opposing party and may at some point want to appear to their donors or constituents to be safeguarding the courts from the radical or reactionary judges that the opposing party would appoint, for the most part, district judge nominees are going to be confirmed, and usually so will Court of Appeals nominees, even where the opposition party has the political strength to refuse confirmation. Moreover, the sheer number of judges who must be appointed makes it impossible for a president or even a Senate committee to thoroughly vet every candidate. District judges tend to be recommended by the senators of the state in which they sit, which even in highly contentious times tends to motivate senators to protect their own patronage by not unnecessarily attacking candidates proposed by their colleagues. There are only about 170 Court of Appeals judgeships, so screening for nominations is more centralized in the White House and gets greater scrutiny by the Senate. But legislative attention for even that many judges is limited. Finally, it's worth noting that judges of the lower courts have very different incentives with respect to how they handle their life tenure. We have a very good retirement program. One of its key provisions is that a judge, upon reaching certain benchmarks of age and service, can take senior status, opening up a vacancy while continuing to sit, often with something close to a full caseload for many years, but with the ability to temper the grueling work of a full-time judge, and most of us do. When I was a law clerk on the Second Circuit in the 1970s, there was a healthy tradition that judges owed it to their colleagues to go senior as soon as they reached retirement age. While regrettably there has been a trend away from that tradition and toward timed departures for political reasons, still, judges on the lower federal courts go senior or outright retire from the federal bench on a regular basis. That assures regular turnover in the lower courts, not the way it works at the Supreme Court. The result of all of this is that the lower court benches are far more politically diverse than the justices of the Supreme Court, and the composition of those courts is less affected by the vagaries of, to be blunt about it, when the Grim Reaper strikes. Not every president gets to appoint even one justice, while some fortuitously have many opportunities. But every president will get to appoint a substantial number of district judges and judges of the courts of appeals. And so long as there is reasonable turnover in the party that controls the White House, and since 1948 there's been only one stretch when the same party held the presidency for as long as 3 terms, the makeup of the lower federal courts will be widely representative of the views of both major political parties. Finally, the decision-making process is quite different at each level of the bench, which has an important effect on the functioning of each court. The Supreme Court always sits en banc, by definition. That is, all 9 justices hear every case. With respect to the subset of cases with the most political salience, which also, by the way, tend to be the hardest, with the least clear guidance from controlling text or precedent, the results are likely to be predictable based on the jurisprudential proclivities of a majority of the justices. A 5 or 6 member block with similar approaches to deciding cases will win every time. But now consider those lower courts. Every district judge is a solo act, king or queen in his or her own court. If issues are close and the law unclear, the individual judge makes the decision, which often, as I've noted, will not be appealed. To the extent that a judge tends, based on his or her experience and political philosophy, to think that litigation is a way for the little guy to hold big corporations accountable, or alternatively, to think that litigation is mostly a drain on the efficient operations on the marketplace, close calls on summary judgment or class certification or whether a pleading is plausible or not are likely to be made differently in different courtrooms. That reality may depart from an idealized model of equal justice if you believe that there is a platonically or divinely ordained right answer to every legal question. It may be distressing to think that not every case will be decided according to what you think is the right answer. But if you recognize that not every tough legal call has only one right answer, and that many have a reasonable range of answers, you will recognize as well that not every case is going to go the same way, and that this may be a feature rather than a bug of our system of justice. The consumer, the worker, the welfare recipient may not win every close case, but neither will she lose them all. The decision-making process at the courts of appeals also differs from that at the Supreme Court. We decide every case in the first instance, and nearly every case with finality, in panels of 3. My court has 13 judgeships. At the moment, there are 6 members who have been appointed by President Biden, 5 by President Trump, 1 by Obama, and 1 by George W. Bush. But there are many senior judges sitting regularly who've been appointed by every president going back to Jimmy Carter. The panels are more or less randomly created, and the cases are assigned to each panel entirely by random distribution. It matters little to the resolution of any given case whether the majority of judges on the court are liberal or conservative. The newspapers are always talking about this or that circuit being flipped by the one party or the other, by winding up with a majority of Republican or Democratic appointed judges. But that doesn't really make much difference to the cases that are decided by particular panels. The easy cases, and there are many, will be decided unanimously because the merits are obvious and the merits are what controls. The close cases will not all go a single way. Narrow issues of law get settled and then are applied as precedents fairly and scrupulously to other cases. But each new issue that arises and presents a close question gets decided by a different panel. And so some rules may turn out to have a more liberal and others a more conservative tinge. Let me note one other feature of deciding cases in panels. In my experience, a body of 3 judges, drawn from a politically and jurisprudentially diverse pool, has some significant advantages. Most of our decisions, as I've noted, are unanimous, partly because most of them are not all that close. But also because the cases that are close or difficult tend to be fairly specific. They don't involve a choice of fundamental political or legal direction, but the selection of which of 2 or more competing principles or ways of reading a specific text will control the result in a highly particular circumstance. There will often be a range of views rather than a binary choice, and there's an opportunity for compromise and a pressure to do what I was taught judges are supposed to do, to decide the least that needs to be decided to resolve the case. The easiest way to lose, the swing voter, where there is one, is to stake out an extreme position that will purport to control the broadest range of future cases. A small group, moreover, can really listen to each other's arguments and try to reach a consensus on a rule of decision that resolves the present case in a way least disrespectful of the concerns that animate those in the minority. This is harder to do in bank, believe me. It starts to seem like a legislative procedure. You just sit there and check off who's voting on which side of the thing. People don't listen as well. Once again, if one thinks, as I do, that many of the hard and novel issues do not have unambiguously right answers, this seems to me a good thing. Would I rather that every case be decided the way I would decide it? Sure, a part of me says. Like any private citizen, I have my own ideas of what a just society would look like, and I would like the law to conform to that notion. But in a democratic society, even one that has certain counter-majoritarian features built in, the ultimate shape of society and the ultimate resolution of issues is a political question that must be decided by the people. I can't expect all citizens or all judges to share my vision. The law that emerges from this system is messy. It's the product of the political choices of the citizenry as expressed through shifting electoral results over time. Each election leaves a residue in the form of legislation that cannot be totally overhauled with every change of administrations. Those elections will also produce a crop of life-tenured judges who will interpret that legislation and will also interpret the vague terms of the Constitution that can trump the preferences of passing majorities. The law, in consequence, does not come from a consistent set of principles from which every rule and every outcome is deduced. Such a coherent body of law would be great if the lawgiver were perfectly knowledgeable and perfectly just. But the vision of such a system, I think, is inherently totalitarian, and it will go drastically awry when the supreme leader or the dominant faction is misguided. A more complicated system gives room for more flexible outcomes that in turn move the entire system in a more moderate direction. That is frustrating for reformers of any stripe. Progress in any direction is slow and proceeds in fits and starts, with cycles in which reformers of the opposite persuasion move the law back in what seems to the last group of reformers a very wrong direction. But I think I prefer that to a more winner-take-all system. The system is unruly, it's a little bit ramshackle, but even as limited to, I've just been describing the federal system and putting aside the great diversity of state law, that has the great advantage of preventing either wild swings in the overall shape of the law or the hardening of a single vision into a perpetual and immovable body of rules dominated by a single philosophy. Let me close by drawing a few concrete lessons from this way of looking at the evolution of law and the structure of the federal judiciary. As I suggest some of these lessons, I recognize they take the form of advice to actors who have little interest in anything I say, and who will most certainly not take it, particularly in our highly partisan times. First, the selection of lower court judges. Federal district judges have a very hard job. It happens to be one that will rarely determine whether abortion will be a crime or a constitutional right, or any other issue of that magnitude. Presidents presumably appoint people whose political and social views and judicial philosophies are roughly congruent with the president's own. But many lawyers will satisfy that criterion. So to the presidents, the judges you pick are the face of fairness in our system. District judges are the only judges that most litigants will ever see. They will have to be calm, poised, and willing to listen. You want people who are smart, who are moderate, not so much in politics as in temperament, who are fair-minded. And no small thing, you want people who will show up for work. Life tenure and judicial independence mean that a federal judge answers to no one. When I took a vacation as a district judge, you know whose permission I needed? Nobody's. You know who I needed to tell about it, that I'd be away for a week or two? Only my own staff. The dumb or the lazy should not be applying for these jobs. The members of the Senate should apply similar criteria. And once satisfied on those matters, they should confirm the choices of the president. In this, I agree with Senator Lindsey Graham, who has pretty consistently noted that elections have consequences. One of those consequences is that the president will get to appoint the judges. Sure, the Senate can vote a few of them down, but the next person nominated will probably be only marginally different in philosophy. So stop with the political theater and the litmus tests. They may be dominating the Supreme Court, but they're not especially relevant in the selection of trial judges, probably not even with respect to courts of appeals. Secondly, the behavior of lower court judges. As noted, they have independence, and so have no more reason to listen to my advice than a president or senator, but consider. Resist the tendency to succumb to black robe disease. You are not infallible. Humility is a cardinal virtue in judges. This mostly affects how you treat litigants and lawyers, but it also applies in deciding legal issues. Adhere to the traditional rule of avoiding broad rulings where possible. Decide only what you must to resolve the dispute before you. And to highlight an issue that's been in the news a bit for the last couple of political administrations, don't reach out to impose a nationwide injunction. Decide the case in front of you, stay in your own lane. If you're on a collegial court, like the courts of appeals, actually listen to what your colleagues have to say. One basic problem with the philosophy that there is a right answer to every legal issue is, of course, that to each of us, the right answer is our answer, the one dictated by our own preferred methodology and our own substantive views. For what it's worth, I have found that sitting on panels with judges whose views on many subjects diverge widely from mine has given me a better understanding of the concerns that motivate their views. My court is not representative of the political views of the majority of voters in the 3 very blue states that comprise the Second Circuit, and certainly not of the academic and liberal neighborhood in which I live. When I was up for nomination for the district court, people from the White House would ask me, how many Republican senators do you know? I would say, I don't know any senators. And I live on the Upper West Side of Manhattan. I don't know any Republicans either. This is a function of the fact that the presidency turns over while the local political majorities don't change. So I have more contact, and more important, I share decision-making power with conservative legal thinkers than I have ever had in any other legal job I've held, or than any of my family or friends on the Upper West Side have had contact. I've learned from these experiences, but you only learn if you listen. Finally, to the Supreme Court. Remember the principles of judicial restraint. Now, I want to say straight out, some of you in the audience may think, yeah, suddenly these liberal judges have discovered judicial restraint now that they don't control the Supreme Court. There is truth in that. But it's also true that I think about these issues rather differently now than I did as a Callow law clerk in 1976. That's what age and experience are supposed to do. They make you more conservative in the truest sense of that word. Times change, majorities shift. The courts get their power ultimately from the reality and the perception that judges adhere to precedent and exercise moderation. Adopting the view, I'm quoting, but I won't say from whom, that no principle is settled until it is settled right, meaning, of course, settled the way I think it should be settled, may allow you to make a lot of change quickly, but it exposes you to the risk that the next generation will be equally able to undo your legacy. And the sense of politicization and instability will reduce the value of the courts as respected and fair arbiters. Take another issue, salient in press coverage of the Supreme Court, the so-called shadow docket. It's a misnomer. It refers to the power to issue temporary stays of lower court orders. There's nothing shadowy about it. It's not secret, except to whatever extent the media used to pay it less attention. Now they pay a lot. But what it does do is to intervene earlier in the processing of cases. Normally, the Supreme Court takes cases only after they've been finally resolved in the lower courts. There are good reasons for that. It used to be said it was good for complex issues to be allowed to percolate through the lower courts, so the Supreme Court could learn from the diverse views advanced as issues were decided by a number of different courts. Spoiler alert, the Supreme Court doesn't care what courts of appeals think. They should. Early intervention into that process smacks of arrogance. It inevitably gives the impression that the justices think that they have nothing to learn from that process, or indeed from having cases fully and carefully briefed and argued before them. If you think that every case has only one right answer and that right answer is yours, well, that's how you'll behave. But I don't think it's the right way to behave. Finally, if we were to fantasize, and it's only a fantasy politically and maybe even unconstitutional, about a change in the actual system, the one proposal for radical change in the Supreme Court that had any appeal to me is the notion of term limits for Supreme Court justices. There would be two valuable results from this. First, it would reduce the pressure on political actors to engage in such practices as appointing the youngest candidates or to engage in extreme vetting of the views of nominees and in bitter confirmation fights by lowering the stakes of each appointment. Second, it would reduce the calcification of views as justices serve for 30 years or more and become political and cultural icons. This can't be good for avoiding judicial arrogance. And third, it would make the Supreme Court bench more changeable and more diverse in political views like the lower federal courts. You can do the math in a way that would result in long terms. We really want being on the Supreme Court to be the last job a lawyer will hold, or at least that will continue in a life-tenured federal position as a senior federal judge, rather than as a stepping stone to some other political office or private profit-making venture. So we want a long term, but we want it to be a term in a way that will guarantee that every president who wins election by the people will have an equal opportunity to leave his or her mark on the court. That's almost certain not to happen, but it would avoid, I think, the long-term tyranny of a court that would follow a single philosophy or be consistently out of step with changing generations of legal and political thinking. If you get the impression that I have some skepticism about the Supreme Court and a great deal of affection for the inferior courts, you are correct. I think that sometimes messy and inconsistent jurisprudence that emerges from the buzz of diverse case-specific judgments of courts grappling with concrete cases and real people is superior to the jurisprudence of philosophers, academics, and judges who deal at a high level of abstraction with broad principles. And that, my friends, is my case against excessive consistency and in favor of the complex and sometimes contradictory principles that animate American law. Thank you very much for your attention. Okay, it was a little longer than I said.
So we have a few minutes here, and then we're going to have a reception in the Zilber Forum where Judge Lynch will be, and one can press other questions on him. But we have time for a couple of questions here if there are some. It was a wonderful lecture. There is no remaining complexity or contradiction, at least in your views. Yes, Bill.
Judge, do you think that federal judges are becoming more polarized in terms of political philosophies that reflect the politics of the public officials who appoint them? Do you think the judiciary has become more polarized, just like our political landscape?
I fear that it is, but ask me in 5 years. I think a lot will depend on the Biden judges. That's not to be critical of Trump judges in particular, but I think that both parties in the last 2 administrations have taken somewhat more political approaches to appointees than even than was formerly the case. And some of that, and I speak now from the perspective of somebody who's more in sympathy with the Biden approach, some of that is very welcome. I mean, it's been a long time since we've had federal defenders. I don't think we've ever had one on our court. There aren't many in the federal district courts. You have one here in Milwaukee, but we don't have many in New York. There are a lot of former prosecutors. So that kind of diversity of experience is very helpful. I think there's no more reason why someone who worked for the Brennan Center or the ACLU should not be appointed to the court than why someone who worked representing corporate clients shouldn't be on a court. So this is all welcome. On the other hand, one of the things that has happened is I think there are fewer people who've had a lot of sort of day-to-day experience in the federal courts. And we have a lot of turnover, so have had a lot of turnover in the last 2 administrations. So this is just speaking about the Second Circuit, not any other court. That means it's harder to get new people sort of acculturated to the traditions of the court. So I think a lot will happen in the next few years that will determine the answer to your question, really. Will these newer judges sort of respond to the traditions of the judiciary in a very healthy way? The jury's still out. I mean, you're still seeing, what happens with new administrations, a few more in-bank applications than is usual, and eventually judges start to realize, wait a minute, in the next administration we won't be in the majority anymore, and then they'll be doing the in-bank applicant. And eventually people learn that this is not the way it should work. But we'll see. But I think there is much more political vetting of judges than there used to be, and that could prove very costly. I hope not.
I think for substantive reasons, that's a good place to leave it. And I want to say 3 things. One, we have a public reception in the Zilber Forum, and there is, or at least history would suggest that there will be, cookies and punch, so please join us. I'm a very cautious man. 2, I want to thank all of you for being here. This is a wonderful revival, if you will, of the annual Hallows Lecture, and I'm very grateful to all of you for being here. And 3rd, without doubt, most importantly, Judge Lynch, we are so grateful for your coming to Milwaukee and enriching our community in so many different ways, including especially this Hallows Lecture. Thank you.